I love the Fifth Amendment. It's why I'm constantly telling people, don't talk to the police. But there's some limitations around breathalyzer tests that you need to know about in case you're ever suspected of a possible DUI. And today I'll argue why I think these limitations are not only silly, but they're unconstitutional. I've had many viewers comment in the past about the different breath tests, and there's a lot of confusion still regarding which breath tests you need to do and don't have to do. Unfortunately, 99% of people don't understand that there are two different breath tests with different laws attached to each. This is a portable or preliminary breath test. This is not the official one at the station that every state requires you to take on pain of an additional charge called refusal. In every state but 7, you can refuse the handheld breath test without additional repercussions. If you're unsure about the law in your state, you should definitely consult with a local lawyer who would be more familiar with your laws. In my expert opinion, if you're stopped in Virginia and you've had anything to drink, you should always refuse the handheld breath test on the side of the road without exception. But if you're in a state that penalizes refusing the handheld breath test, you would have to decide if the punishment for refusing is worth the potential gain. As a lawyer, I can't advise you to break the law. So if most Americans can simply refuse this test, what's it good for anyway? It's just another tool, trick, and trap for the police to use to try to get you to voluntarily incriminate yourself so they have more evidence to arrest you for a possible DUI. Since you watch this channel, you already know that you're going to refuse the roadside field sobriety test if you ever stop for suspicion of DUI. And you should also refuse the PBT if that's allowed in your state. But how does your right to remain silent play into all this? Because I always tell you, don't talk to the police. You always have the right to remain silent, even if the officer doesn't tell you that you have the right to remain silent. Plead the fifth. You don't have to answer whether or not you will take the handheld breath test. However, if you're in one of the handful of states that does penalize refusing the PBT on the side of the road, then actually saying no to that test could be used to incriminate you and possibly convict you for a roadside refusal. It's ridiculous. If you're in that situation where you're required to take the test on the side of the road, I would encourage you to not say no, but I think you do have some leeway to simply not answer the question. Then, if the officer puts the test in front of you and you physically continue to refuse to blow, I think there's a strong chance that you could be convicted of refusal. Note that this applies only in a small handful of states that actually penalize refusing the roadside breath test. So what's the other test that you can't refuse in any state? It's the one that's back at the police station, and it's giant. In Virginia, we use what's called the Intoxilyzer ECIR2. It looks kind of similar to a Tandy 1000 SL, my first computer. And here's where things get really stupid and unconstitutional. Every state has what's known as implied consent. That's fancy lawyer talk, which basically means the police don't have to ask your permission to make you submit to the breath test or a blood test if there's reason for that. By simply driving on a public highway, you're deemed to have already consented to those tests. And this means that if you are lawfully arrested, you must provide a breath or a blood sample depending upon your state's regulations. Failure to do so can result in pretty severe penalties, including an automatic suspension of your driver's license. But don't we have the right to not incriminate ourselves? Isn't that what the Fifth Amendment is all about? Yes. But our country long ago decided that policing DUIs was more important than the Constitution. And here's how that played out. The Fifth Amendment says, no person shall be compelled in any criminal case to be a witness against himself. The key word here is witness. The courts have long held that being a witness means to provide testimony, which essentially boils down to someone asking you questions and you providing answers. This is why, if you're in police custody and they haven't read you Miranda and you voluntarily say things without being questioned, those can be used against you. Nobody's questioning you, so you're deemed to not be a witness at that point. You're just running your mouth on your own accord. Here's an example that I see often.
Now that you're under arrest, we're going to take you down to the police headquarters to blow into the mandatory breath test. Are you going to blow in that machine for me, son? Officer, I'd like to help, but I'm way too drunk for that.
The Supreme Court analyzed this precise scenario in South Dakota versus Neville. The court held that the officer is not coercing anything out of the defendant by asking if the defendant will submit to a breath test. Therefore, this is not a violation of the Fifth Amendment. And I agree with the result in the Neville case. In that case, the officers read Miranda to the defendant. He knew he had the right to remain silent. He was warned that anything he says will be used against him, and he actually answered the question saying no, he's not going to submit to the breath test. He could have remained silent, but didn't. But there's a Virginia case, Acuna versus Commonwealth, that I think goes too far. In Acuna, the officer arrested the driver for suspicion of DUI, but did not read his Miranda rights. The officer then proceeded to ask Mr. Acuna if he would take the breath test, to which he responded out loud that he would not. Now you would think that because Mr. Acuna was in police custody, he was not read his rights, and the police are asking him a question, that this would be a Miranda violation, so that his answer to the question about the breath test should not be admissible in court against him. But the Virginia Court of Appeals allowed Acuna's answer into evidence based on the Neville reasoning, that the question about the breath test is not coercing anything out of the defendant, and therefore it's not a violation of the Fifth Amendment. This is all fancy lawyer talk that basically means we've created a breath test exception to the Fifth Amendment. If the officers have you in custody and ask whether or not you're going to take the breath test, your answer can be evidence against you whether or not they've read you your rights. Welcome to Virginia, where the laws are made up and the points don't matter. But there's still a gray area. What if you're asked whether or not you will submit to the breath test, but you don't say anything in response? You simply remain silent. The government could probably admit your silent non-response into evidence based on the Neville and Acuna reasoning. However, silence is not the same as saying, no, I'm not going to take the test. Therefore, your silence in response to that question shouldn't be enough to convict you of a refusal. This is why officers shouldn't ask you if you're going to take the breath test. Frankly, it would be a much stronger case for them if they simply sat you down in front of the machine, started it up, advised you what you're going to do at the appropriate time. Then, if you don't physically blow at the appropriate time, they would have a strong case for refusal, and you don't have to get into any of these weeds about Miranda and the Fifth Amendment. Always remember that your best defense when confronted by the police is to shut up. And that advice holds true on the road or at your own front door. So check out this next video about how a police officer was arrested at his house for DUI without being even pulled over. I'll see you over there, and remember, don't talk to the police.